were approached by Sompuli.
Yeah.
And William, I think it's the late William Kipkut or something.
Yeah.
Yes?
Yes.
To actually purchase after the transaction of stroke 19. 18, you did not involve yourself with the purchase of stroke 18?
Sompuli was not involved in that, if that is the one. In whose name is 18?
Yes.
So that we know we are talking about the same.
Can we clarify
Yeah.
the number?
Yeah.
Yes, let me give you
because numbers, yeah.
My Lord, perhaps to assist the court counsel would refer to the statement so that the witness is able to connect what he's asking about.
Yes, let me do so.
His witness statement for one page.
My Lord, that one is in the Kanyongo bundle so that we are able to know what is being discussed so that the witness does not then discuss something different from what counsel is asking about.
Your Honor, the problem is, and I'll get to that, he did not mention this in his statement. He actually mentioned it in examination in chief. So it is what he actually mentioned in examination in chief, even though it's mentioned by PW1. That is the law. But in terms of the aspects that I'm asking, that's why I want to get to the exact wordings so that he can remember. But in none of these statements will you find that this particular issue. Actually, it is in the Kanyongo bundle. That is D2, then Roman 2. That is the fourth paragraph. Are you there?
Yes, I'm there, my Lord.
Now, that is the stroke 18 that I was referring you to.
Yes, ma'am.
Stroke 18.
Yes, my Lord.
And in your statement there, you are clear now that in that statement it is Mr. Andrew Sompuli who approached you. That is the fourth paragraph.
Yes, my Lord.
So now you remember that.
Yes, my Lord.
Thank you so much. And there is an argument which you'll still find on B27, Roman 1 of the same bundle. There is a sales argument dated the 15th day of December, 19th day of December 2012. B27 is almost in the past the middle of the document. B27, Roman 1, if counsel can assist.
B for boy?
Yeah, B for boy.
Yes. My Lord.
So by the time you are going to see the president, and you have indicated here, the first thing was to thank him for that Gertrude property.
Both, my Lord.
Was to thank him for both.
Yes, my Lord. It was one meeting for both.
Nonetheless, there were two properties that you were thanking the president for.
Yes, my Lord.
Who transacted? Who was the advocate of the president in that matter?
I want to believe Mr. Obati.
You want to believe?
Yes.
You do not. Do you have evidence of that?
No, my lord.
You do not have evidence because it is not, but you will not go past that. I will delve into that later. For now, this particular property that you bought, was it fenced? Did you fence it?
It was fenced, my lord.
Who fenced it? No. The Gertrude's property.
It was fenced when I bought it.
Who fenced?
It must have been fenced.
Or it was fenced by the time you were buying?
That's what I'm saying, my lord.
Fair enough. That was fenced. After, you say that you also bought 12422/20.
That's the Gertrude one.
That is the Gertrude one.
Yes, my lord.
The one that is fenced,
Yes, my lord.
which is adjacent to stroke 19.
No, not my lord.
It's not adjacent to stroke 19.
No, my lord.
Which property? You said you got a property that was adjacent to stroke 19.
I have a property next door. I'm immediate neighbor for stroke 19.
Which property? What is the number?
Mine, I believe 20 or 18.
20 is the one you told us is the Gertrude one. I asked you, there's 12422/20.
I thought you were reading from the document. That's why I said yes, because I had said I can't remember the LL number.
Okay. Thank you. You indicated that there is a stroke 20. Okay, let me go to the specific ones to avoid then the confusion, because I got them also from your statement. Whatever the property adjacent to stroke 19, is it fenced?
Yes, it's now fenced.
Who has fenced it?
Myself.
You bought it and you fenced it.
Yes.
When did you fence it?
Recently. It was also fenced the same way with barbed wire, but recently I fenced it with a stone wall.
That's what I want. Previously, after you bought it, it was fenced with barbed wire. Who fenced the barbed wire?
Myself.
Yourself.
Yes.
So you actually bought the property and fenced it to indicate you have taken possession.
That's true, my lord.
And even recently, you've even gone further and put a stone fencing.
Yes, my lord.
Stroke 19, you tell us that you bought it in 2012.
Yes, my lord.
Did you put a barbed wire fence?
It was fenced already.
Stroke 19.
Yes, it was fenced.
Property.
Yes.
You're sure?
Yes. Concrete post and barbed wire.
So that if you tell you that evidence in this court is that that property was never fenced, it has actually been fenced by the third plaintiff.
My lord, that will not be factual. This is a property that is my neighbor for 15 years before this transaction of 2012. I know it the way I know because it's the immediate plot.
Fair enough. We have pleadings by all parties on that one. Let me not delve too much on it. Nonetheless, you indicate that you took possession of that property.
Yes, my lord.
How did you take possession?
By the same staff who look after the other. They extended looking and utilizing the plot.
Which staff?
The staff on my property next to it.
Yes?
Yes.
Have they done any statement in this court to show that they are the people who are mandated to look after that property?
No, my lord.
We do not have that.
Yeah.
Do you know that USIU indicated that they were the ones in possession?
No, my lord.
You do not know that?
Yes. Because I used to.
Do you know that Maestro, that is the third plaintiff, took possession of that property and there was no one in possession, and that is their position in this court?
No, my lord, but it was fenced.
It's okay, I'm just telling you. that they took possession. Maestro took possession, USIU says they also took possession. Now, if Maestro, currently, who is in possession?
I believe the status quo
Which is what?
I believe I am in possession.
You can't believe. You don't even know whether you're in possession or not.
You know, let's differentiate semantics. As I said, I've been using this property to harvest grass
So
from
are you still
inception.
harvesting grass today?
No, at the moment, no,
Why not?
because of the dispute. You respect the court, and that's why I'm here, so that the
So
court
you are
finds
not in possession, in simple terms.
the subject lad is before this court for determination.
Even if you don't want to answer, Maestro Connections is in possession of that. If there is an order of court on that. In that respect, I don't want to delve so much into it. Because you have told the court you are in possession, I wanted to clarify that issue. But I'm happy we are clear you're not in possession as is known in you.
I've continued to harvest grass, remember?
You continue to harvest grass?
Yes.
When was the last time you harvested grass? And remember you're under oath.
Yes, my lord.
When did you harvest grass last year?
As I said, from 2012 all
When did you
through,
last harvest grass?
up until the dispute brought this matter to court,
2016.
2016.
From there you have not been harvesting grass.
No, because it's a subject of a court.
Have you visited that land?
It's my neighbor. I pass there every
Do
time.
not see there are people inside?
There are no people inside.
There are no people inside.
Yes, to the best of my knowledge.
There are no machinery is inside there. Dr. Mwangi.
There is no people who are working on that land. It's in bush.
There are people inside. You know, if it's your property and someone is inside, you even report to the police. They are trespassers in my property.
This matter has been reported by our lawyers at 2016 and investigated.
Let me tell you why you could not report. Because you knew you were conned. And this is not the first time you were conned. There is a property that is adjacent to it called 1242.
Yes, my lord.
You can see that. So you just put your fingers on that one so that we'll get back to it just in case we need further clarity. Now, this offer was actually coming after you had completed the stroke 19.
Yes, my lord.
The vendor in this particular sale is the same, His Excellency Daniel Arap Moi.
Yes, my lord.
Did he tell you that?
We went to President Moi to present his lawyer.
Leave that is 2013. I'm saying at the initiation stages.
Mr. Okatchi was dealing with our lawyer. It was a counterpart to our lawyer. I was not dealing with Okatchi. Meeting Okatchi doesn't mean dealing with Okatchi.
You met him.
Yes.
You have told us you met him and you knew he was President Moi's lawyer.
No, we don't say that. We couldn't have gone to President Moi. We went to be given the lawyer by President Moi. I believe that was the objective.
You went and President Moi gave a lawyer.
We went, and I believe, and the lawyer can verify for Muthaiga,
Yes.
that it was important for President Moi to confirm that he was sent, and then preferably have the lawyer.
And
we
that
were
happened before all these aspects of getting into the agreement as is expected. That meeting should have happened before even the agreement itself was signed. It cannot happen after.
It can, because the sequencing for me, let me, my lord, help the court from my own perspective. The most important day for Muthaiga was when I signed for Muthaiga. And we can talk about the date I signed for Muthaiga. When I signed for Muthaiga, a search had been done. It was confirmed the details.
We will get to that. I'm asking you.
And the visit to President Moi had taken place.
Listen, you have been told that the asset of the former president, the position of the former president in this court, is that he never dealt or sold this parcel to yourself. And that's why it is important, even for you as a party, to understand why that position may be true, if at all it is true. And that's why I'm asking you, listen, that's why I'm asking you this very important question. Your lawyer was getting back to you on what, even at least that meeting. At least she told you what happened in that meeting.
You know, my lawyer has a delegated authority to deal with the transaction. We said
Without getting back to you.
as a family, we don't understand the process. So we took the risk of a lawyer like we have taken all along to deal the transaction the right way.
I like the word risk. You took a risk. You knew you were taking a risk.
Everything you do is you take a risk on everything. There's nothing you don't take a
Fair
risk on.
enough. Now, let me tell you why it was a very big risk that you shouldn't take. Now, introduction of this lawyer, whether you, and this meeting, whether it was whatever sequence or period you want to say, at least it should have taken place before close of this transaction. There will be no meaning of more introducing a lawyer